Bom, primeiro, então, bem-vindo a todos. Masato. Thank you, thank you, professors. Recebemos aí 3 grandes palestrantes, temas desde minerais críticos até cooperação jurídica internacional, nova convenção, proposta de convenção de Haia. De novo, obrigado, professor Masato, por organizar o nosso evento, por trazer mais professores para cá e compartilhar esse conhecimento que só o senhor consegue trazer aqui para São Fran. Convido o professor Masato para sentar-se à mesa e presidir os trabalhos. Obrigado, professor.
So, good afternoon, everybody. Thank you very much, Professor Takeshita, Professor Kobayashi, and Professor Shimizu. As I told you, and I show you, this is a faculty of law, Sapporo University, which is one of most traditional and old faculty of law in Brazil. This faculty, this school was founded August 11th, 1827, together with the same school in Recife, Pernambuco. So we are founded together, yes. And very traditional, as I showed the building already. And many Japanese professors have been here. They spoke not only in this room, but the other rooms. Beginning with Professor Kotaro Tanaka, as I showed you before. Professor Ikehara, Professor Hoshino, Professor Dogauchi, many professors came here. And some of them spoke in English, as you are going to speak. And some people spoke in Japanese, and I was a translator. So today, if after you are going to speak in English, and I wanted you to begin with your self-presentation of your service. And then if people have some question to do, yes, I will be your disposal to answer and questions. Thank you. So Professor Takeshita, you are the first one, please.
Okay. Good afternoon. Oh, okay. Good afternoon, everyone. Thank you for coming to our certain study meeting. My name is Keisuke Takeshita. I'm a professor of private international law at Hitotsubashi University in Japan. Actually, as I am a private international law scholar, I myself studied the theory of Kotaro Tanaka. Yes, in a sense, he is he wrote a book, which is, if I translate the title of the book into English, Theory of World Law. In this way, Kotaro Tanaka has very globalized mind or something like that. And I truly love it. And from that kind of, from that perspective, I myself study private international law. Then today, but I will not talk about the theory of private international law. However, currently, I am engaged in international project, which is called Jurisdiction Project at the Hague Conference on Private International Law. I'm not so sure who knows Hague Conference on Private International Law. Unfortunately, nobody knows. Very small international organization. However, it is truly an international organization which have, as I will later told, 91 member states. And the Hague Conference on Private at Hague Conference on Private International Law, currently there is a project which try to draft try to make the draft of the convention. And yes, as I am the chair of the project itself, and therefore today I would like to talk about this project, and I would be very, very happy if you could know it, just know it. That's okay. But yeah, in any case, I'm not so sure whether private international law is popular in Brazil or not. However, in any case, from my perspective, private international law is truly, truly important for the globalized world because this is the basis of the international cooperation. And from that perspective, I will talk about this project. Yes. Where? No. Where? Wait a moment. No. Can I? Could you please start the slideshow and thank you very much. Okay. Thank you. I'm sorry, I cannot read Portuguese, and therefore. In any case, this is a table of contents of my today's talk. First, as you don't know, the HCCH, Hague Conference on Private International Law itself, that's why I will introduce to you this international organization. And after that, I will let you know the, in a sense, overview of the jurisdiction project. And after that, currently, the jurisdiction project has a 2025 October draft, which is drafted in the working group of the jurisdiction project, which I chaired. And I would like to let you know the features of that draft convention. And after that, what is difficult or challenges of the project itself? And I conclude my presentation by some remarks. Yeah, let's move on to the first. Yeah, in any case, today I will talk about the certain draft provisions of the jurisdiction project. And if you're interested in the provision itself, then you can visit this HCCH website, and you'd be able to find the detailed information at this page. And if you would like to know detail, then please visit the HCCH website. In any case, first, I will introduce to you the Hague Conference on Private International Law. Yeah, HCCH stands for Hague Conference on Private International Law and Conférence de droit international privé. That's a French word, French name of this organization. Yes, Hague Conference on Private International Law is a global intergovernmental organization for cross-border cooperation in the field of private international law. The motto of the Hague Conference on Private International Law is building bridges between different legal systems. As you probably, as you would know, private international law, yes, basically jurisdiction issues, recognition and enforcement of foreign judgments issue, and the choice of law, applicable determination of the applicable law issues. Those issues were discussed based on the coexistence of judicial systems and how to bridge, how to harmonize the dispute resolution or something like that. This is the issue of private international law. And for that purpose, this international organization tried to realize the progressive unification of private international law. Yeah, actually, as I told you, Professor Kotaro Tanaka also thought that private international law should be unified in a sense. One private international law should be valid for all over the world. Actually, currently, as you know, private international law itself is a national law. However, from the viewpoint of the theoretical nature of private international law, it should be certain global rule. And to realize that situation, this international organization tried to make convention or other international rules. And by doing so, it tries to progressive unification. It tries to do the unification of private international law. And currently, this organization has 91 members, 91 sovereign states, member states, and one regional economic integration organization. That is European Union. Yes. And I would like to let you know the brief history of not private international, but HCCH. Yes, this conference held its first meeting in 1893 on the initiative of Tobias Asser. Who knows Tobias Asser? Nobody knows. He is a Dutch diplomat and who won the Nobel Peace Prize in 1911. Yeah, before moving on to the next point, I would like to show you this handschrift of the Tobias Asser. This is the title of this handwriting is the international law in Japan. Yes, he is truly interested in Japan, and he helped Japan to participate in the conference itself. Yeah, actually, this conference started by the members, only European countries. Only European countries attended at the first meeting. However, from the fourth meeting held in 1904, Japan started to participate in this meeting of HCCH. Therefore, Japan itself has more than 120 years history with HCCH, and it became a permanent intergovernmental organization in 1955 upon entering into force its statute. After the World War II, it formally became the so-called international organization. And I did not, but Brazil had been a member of HCCH from 27th January 1972 until 30 June 1978. I didn't know that why Brazil withdrew from this organization, but it rejoined on 23rd February 2001. I myself did not know this information, and therefore, I cannot explain to you why Brazil once withdrew from the international organization and after that rejoined. But in the future, I will check why. Therefore, I cannot answer to this point. In any case, currently Brazil is also a very active member state. And yeah, actually, so-called General Assembly, which is called CGAP, Council Council of General Affairs and Policy. The chair of the CGAP is Brazilian. And yeah, this international organization has made 41 private international law instruments, 40 conventions, and one principle. I'm not so sure, but maybe you would know the so-called Child Abduction Convention. And this is made in this HCCH. Yeah. Then next. Yeah, let's move on to the next part, jurisdiction project. Yes, here I would like to let you know the overview of the jurisdiction project. Yeah, actually, the jurisdiction project is a legislative project for new international instruments relating to the which deals with matters relating to jurisdiction. And including parallel proceedings and related actions. Parallel proceedings, maybe you would understand, yeah, the same subject between the same, for example, if there is a dispute between the same parties, and one party go to the US court, the other party go to the Japanese court. In this way, in courts of different countries, same subject matter between the same parties will be adjudicated. In such situation, this is a parallel proceedings. And yeah, actually, it seems to me that this is, in a sense, waste of judicial resources, and it should be one court should deal with the case. This might be the better. And to realize that situation, we are now drafting a convention. And originally, there was a judgments project. This is a legislative project concerning international jurisdiction of courts and the recognition and enforcement of foreign judgments in civil or commercial matters. In a sense, in the judgments project started in 1992, and it tries to deal with two of the important pillars of private international law. Actually, as I let you know, private international law consists of three pillars. One is international jurisdiction issue. The other, another is choice of law issue. And the third point would be the recognition and enforcement of foreign judgments. And the judgments project originally tried to make a convention on jurisdiction and recognition and enforcement of foreign judgments. And this is a sister project of the jurisdiction project. These two projects are interconnected, but why we are now discussing jurisdiction project, irrespective of the fact that the judgment project itself deals with international jurisdiction. I will let you know the history of this project. Yeah, actually, originally 1992, the jurisdiction project started by the proposal. If my understanding correct, originally this project is proposed by U.S. delegate, and after that, in 1999, preliminary draft convention was in a sense, adopted as the special commission of the Hague HCCH. This preliminary draft convention is, in a sense, overall draft convention, which we include the rules of jurisdiction, recognition, and enforcement of foreign judgments. However, in 2001, at the diplomatic session, yeah, as you know, international convention is always adopted as a diplomatic session. However, adoption, the draft convention was not adopted, failure of adoption, because jurisdiction issue closely relates to judicial sovereignty, and some country very hesitant to restrict certain sovereignty by this convention. That's why, at the diplomatic session, the preliminary draft the convention itself was not adopted. And after that, the HCCH tried to, even if the failure of adoption, HCCH tried to make certain convention and tries to draft a more focused convention. And as a result, in 2005, so-called choice of court convention, which deals with the choice of court agreement. This convention was adopted. And the project itself, judgments project itself, postponed. However, in 2011, the project itself resumed and started to discuss another issue, which originally tried to solve. And there was a first and the second experts group, and after, as a result of the discussion, HCCH decided to draft a convention on recognition and enforcement of foreign judgments, and successfully in 2019 Judgments Convention, which is a convention on recognition and enforcement of foreign judgments. This was adopted in 2019. And after that, what remained? Yes, jurisdiction issue. And therefore, from 2020, third experts group, actually, first and second experts group of the judgments project was held in 2011, and the 2020 third experts group was held. But the issue itself is or was already focused on international jurisdiction. That's why the name of the project was changed to jurisdiction project. And 2021, CGAP, the so-called General Assembly of the HCCH, decided to make the working group on jurisdiction, which drafts, whose mandate was drafting provisions for discussing in the so-called special commission. And actually, in 2025, 8th and 9th meeting was held, and at least in my understanding, the working group finished its work. It means that it drafted certain draft provisions for the future convention. Yeah, actually, at the HCCH, yeah, usually the procedure for making convention. First, we will discuss the feasibility of the certain topic which the future convention will deal with. Feasibility would be studied at the experts group. And after that, if the answer is yes, then after that, there will be a working group stage. And after the working group stage, special commission will be established. Special commission consists of all member states of the HCCH and discuss the draft to submit to the diplomatic session. And finally, at diplomatic session, we will adopt a convention. I would like to do so. And currently, almost working group stage is finished. And as I told you, as for the experts group and the working group, I was chairing the jurisdiction project. And therefore, based on the experience of the chair, I will let you know the contents on the certain challenges of the jurisdiction project today. Yeah, maybe in CGAP 2027, next March, I truly hope CGAP will determine the upgrade to the special commission. By doing so, this project continues. But it might happen that CGAP denies the upgrade. I'm not so sure. It depends on the intention of the member states. Yes, I will let you know let's move on to the next part, features of 2025 October draft. This is the newest draft for the future convention, which deals with parallel proceedings and related actions. Yeah, as I told you, on the website, you'd be able to find the draft text of a future convention on parallel proceedings and related actions. This is included in the document as next to the Working Group on Jurisdiction report of the 9th meeting, which is also annexed to the main report. And therefore, in any case, maybe you'd find the CGAP 2026 page and preliminary document number 2A. This, if you see this document, you'd be able to find the current draft provisions. And the core provisions of the draft is rules for parallel proceedings and rules for related actions and rules for flexible mechanism for communication among states. These three rules are the main content of the draft for the future convention. Yes, the purpose of the draft is actually this is simple: access to justice for all, obliging contracting states to suspend or dismiss the proceedings of their courts if there are proceedings in a more appropriate court of another contracting state. Then the first contracting state should be suspended its proceedings. And by doing so, the draft tries to enhance access to justice for all. However, actually, this draft focuses on multiple or concurrent proceedings. The draft deals with cases where several proceedings on the same or related matters are pending in courts of different contracting states. The draft tries to provide greater predictability and certainty, reduce costs for dispute resolution, and avoid the risk of inconsistent judgments by this new instrument. In other words, yeah, the new convention will not have the rules on so-called direct jurisdiction or international jurisdiction. Why? Maybe you'd guess. Yes, the rules on international jurisdiction itself, in a sense, closely relates to the judicial sovereignty of each state. And actually, I cannot tell which country strongly denied denied making of such rules. However, relatively easily, you would be able to relatively easily imagine. Yes, some countries strongly argue against the inclusion of the jurisdiction rule itself. On the other hand, yeah, if there is a multiple proceedings or concurrent proceedings, it should be only one court should continue the proceedings, and another court should suspend or dismiss. By doing so, maybe we can reduce costs or maybe we can avoid the considerable judgments. And that's why we focus on multiple proceedings. And the first one might be a little bit, sorry. A very simple example of parallel proceedings. When, sorry, here I thought that I have put it. I had put a certain mark of the company, however, we cannot see. In any case, for example, there is company A in state K and company B, state J, made a contract. And for example, in state K, A sued B seeking for compensation of damage, and in state J, B sued A seeking for declaration of no liability. In such situation, same subject matter is dealt with by those two courts. And in order to reduce costs or avoid the irreconcilable judgments, we are trying to make a rule, and only one court should continue, and another court should suspend or dismiss the proceedings. And basically, these rules for parallel proceedings, which is provided in Article 5 to Article 10 in the draft, these rules specify the more appropriate court. More appropriate court should continue the proceedings, and other courts should suspend. And proceedings in other contracting states courts shall be suspended or dismissed. And then how we specify the more appropriate formula, that might be the issue. And there are some rules for the specification of the more appropriate forum. The first rule is if the subject matter of the dispute is rights in rem in immovable property, then, needless to say, the court of the country in which the immovable property itself is situated, this court has a certain priority, or this court is a more appropriate court than courts in another contracting state. Therefore, other contracting states proceedings should be suspended. And second rule would be the party autonomy. If parties agree to adjudicate their dispute in certain courts, then that court should be prioritized. Other courts should suspend or dismiss. Then third rule is the priority based on jurisdictional correction. Yes, actually, in this draft, we provide a certain grounds of jurisdiction or connection. And it means that if a court of a contracting state which has a connection, that court would be, in a sense, appropriate court. If a court of a contracting state, which if the proceedings are pending before the court of the contracting state, which has a connection, and another proceedings in another court in another contracting state, which does not have such connection, then the court of the contracting state, which has a connection, should be prioritized. In this way, based on the rules on jurisdictional connection, we determine the priority court. But it might happen that both courts have such grounds of jurisdiction. In such situation, like the forum non-convenience or better forum approach in common law world, each court analyze which court is more appropriate or something like that. In this way, we determine the more appropriate forum. This is the rules for parallel proceedings. And the second pillar of the draft is the rules for related actions. This is here I explain the Japanese a case of Japanese Supreme Court judgment on 10th March. It is a case of related actions, and again, maybe mistakenly. I forgot to put the mark of the company or certain thing. Yeah, actually, but this case or the story of this case starts that Japanese pinball company. I'm not so sure whether you'd know the word pachinko in Japanese. Japanese pachinko company, pinball company, had the share made the child company in USA, and the child company had a share of US company Y, which is a casino business company. And however, the CEO, Chief Executive Officer of the Japanese pachinko company, maybe or it is reported to the directors board of the company Y that X2, the chairperson of the Japanese pinball company, that he gave bribe to the officials in East Asian countries. And needless to say, in the US, casino business, such person should not be engaged in the management of those companies. Therefore, the board of directors of company Y decided to redeem the A's share, and as a result, by doing so, company Y should, in a sense, keep the appropriate management of its company. And in US, the company Y sued X because it would like to confirm the validity of the redemption of A's share. On the other hand, in Japan, yes, X sued Y for the compensation of damage resulting from defamation. Yeah, actually, the company Y's report, yes, which says X2 gave a bribe to the officials in East Asian countries. That information was published on the internet. That's why X2 arguing that I did not do that, arguing that brought an action to the Japanese court. This is truly so-called related actions. The subject matter itself is different. However, the issue itself is closely related. And as a result, yes, of course, this is based on the based on the determination by the Japanese national rule. However, Japanese Supreme Court dismissed the case without prejudice because U.S. courts should deal with the case, should deal with the issue of defamation itself, together with confirmation of validity of the redemption of A's share. This is an illustration of the related actions. And let's go back to the contents of the draft. As for the rules of related actions, very flexible rule. They provide the consolidation of the proceedings of related actions in courts of different contracting states. Yeah, actually, there was Japanese proceedings, US proceedings. Yes, probably consolidation to the US proceeding. It might be reasonable. To realize those consolidation, there are provisions. And conditions for consolidation. Consolidation will be realized only when both courts of related actions have the same view on the questions. It means that on the questions whether a single court should adjudicate the entirety or any part of the related action, and if so, which court is a better or more appropriate forum for the resolution of the entirety or any part of the related actions. Which means that, yes, upon the application of the party, if I explain based on the previous case, Japanese court would consider this issue should be consolidated to the one court or not, and the Japanese court would consider yes. And the Japanese court would consider that, yes, US would be the more appropriate court. And US court also needs to consider whether these issues should be dealt with in one court or not. And the US court would consider, yeah, US would be the appropriate court. Both courts think of same conclusion, then consolidation will be realized. This is the provisions in the draft. Then, therefore, very flexible, I can say very flexible rule. And as for the rules for communication and cooperation, yeah, actually, as for the related actions or parallel proceedings, both courts should communicate to exchange information. For that purpose, the draft has rules for judicial cooperation, such as exchange of relevant information when the proceedings when the court is seized or something like that. Such judicial cooperation might be necessary to apply the provision of the draft, and therefore very flexible cooperation mechanism is drafted in the and the first point might be the communication mechanism. Yeah, in this convention, 3 methods of communication are provided. First method would be direct court to communication. Brazilian court judges calls for US court judges, blah, 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 communication. I'm not so sure whether this is a telephone or email or something like that. I'm not so sure. However, such the possibility of direct court-to-court communication is provided. And another method would be the communication through competent authorities. Not the court itself, but certain competent authority communicate each other by doing so. For example, as for Japanese judges, they are not good at speaking English. I'm so sorry. I'm not also not good at speaking English. I'm so sorry. However, it is quite difficult for Japanese judges to communicate with US judges directly. That's why there would be a competent authority, and the competent authority communicate each other and exchange information. And the third method would be the communication through parties. This is, at least in my understanding, this is a usual communication in the courts. And for example, Japanese court asked parties, what is happening in US courts? And the parties would let the judges know the information. In this way, there are rules for communication mechanisms. Yes, maybe method C might be very usual. However, A and B is quite new for usual, for current situation, from the viewpoint of the current situation. And in addition, in Article 17, there is a provision of joint hearings. US judges and Japanese judges jointly conduct hearings. I don't know how it can be realized. However, because of the development of the technologies, it might be possible. This is so-called cooperation, and this is the rules for communication and cooperation mechanisms. Yeah. Now I would like to let you know some challenges of this project. Yeah, actually, it maybe in the near future, we need to confirm again whether there is a consensus on the basic policy itself. Even if the situation of parallel proceedings, one court needs to be dismissed or suspended under the convention, it can be regarded as certain restriction of judicial sovereignty. Whether member states of the HCCH would agree or not, it is truly an important issue. And another important or difficult issue might be how to compromise the different thoughts. Yeah, actually, as for the parallel proceedings in the world, there are two principles. One would be the so-called first-in-time rule, which is adopted in the EU countries. First court should have a priority. On the other hand, in many other countries, more appropriate forum analysis would be used for dealing with parallel proceedings itself. Then some countries argue for first-in-time principle. Another country argue for more appropriate forum. Then when we make conventions, there should be an innovative third way. What is the innovative third way? We need to consider further. And in addition, currently the draft itself is, from my personal viewpoint, too complicated. However, the future convention would be applicable not only in the country whose mother tongue is English, but also other, for example, Asian countries like Japan or other countries. And therefore, it would be necessary to simplify the provisions. And in this way, if we consider, when we drafting, we are considering the application, global, in a certain sense, global application. Everywhere, every country's judges, we might apply this convention. Therefore, it should be understandable. It should be simplified. How to realize this might be the challenges. And the final point might be too ambitious. This might be the question. Joint hearings or direct court-to-court communication, it might be too ambitious. However, actually, from my perspective, it can be provided because this convention is not for old people like me. This convention will be applied in the future generation. And if we consider the application in the future, such joint hearings or such communication and cooperation, joint hearings or direct court-to-court communication, it might be possible. And such possibility should be considered in drafting provisions. Those are truly difficult challenges, but in any case, maybe I will continue the chair of the project. I will try hard to tackle with those challenges. And sorry, too long maybe, but final word. No, there is no picture. I put some picture here, but in any case, from my perspective, this is the age of global cooperation for dispute resolution in civil or commercial matters and the connection to the next generation. As I told you, we are now trying to make convention not for the current, not only for the current birth, but also for the future world. And therefore, I would like to let you know that when making rules, registration, when conducting registration, then in these situations, not only the current situation, but we need to, in a certain sense, imagine the future situation. This is truly important, and I would like to let you know. And by doing so, I truly hope we would be able to establish cooperation regime for the future better world. Now I conclude my presentation. Thank you very much for your kind attention.
Thank you very much, Professor Takishita. Do you have any question?
Yes, please. Oh.
My name is Alexander. I have a question about, in your opinion, if how Japan see this project, and if Japan tends to accept this jurisdiction project.
Of course. Yes, I truly hope Japan would accept. But this is just a joke. However, Syria currently, maybe if my understanding is correct, Brazil would have certain bilateral convention or something like that as for the recognition and enforcement of foreign judgments. However, actually, Japan have almost no such kind of convention. And therefore, in Japan, issues of private international law is dealt with by the domestic rules. And however, Japanese government itself, my colleagues as the Ministry of Justice and Ministry of Foreign Affairs, they recognize that certain private international law rules should not be the domestic rules. That's why if the HCCH can successfully adopt certain convention, then probably Japanese government would consider the in a sense, accession or ratification of, as I told you, 2005 Choice of Court Convention, 2019 Judgments Convention, and the Future Convention. These three conventions is, in a sense, piece of the big international regime, and therefore Japanese government would consider that if this project, if in this project, jurisdiction project, there would be a new convention, I mean, new convention is adopted, then maybe at least in my understanding, Japan would consider seriously, and maybe in the future, it will be Japan would accept such kind of convention. This is my current opinion.
Okay, nice. Well, Professor Takeshita, you asked us why Brazil joined the Hague Conference in 1972 and why Brazil left 1978. Yes, I know the reason. Everybody knows here who is Professor Haroldo Varadão. Haroldo Varadão was born in Rio de Janeiro, 1901, and he passed away in 1987. He was a good friend of Professor Ikehara. From 1972 to 1978. Why Brazil joined Hague Conference 1972? Because Professor Haroldo Varadão wanted to. He was a one-man Brazilian scholar who participated every international conferences. He only him by himself. He used to go to The Hague by alone, by Brazilian government expenses. Went to the Brazilian embassy, The Hague, just hired one young diplomat as his assistant, and he used to participate all sections together. Only one man. When he lost the interest in the private international conference, he suggested government to leave. Brazil leave the conference. Yes, Professor Haroldo Varadão was a great professor of private international law. There was other people. Yes. For example, Luiz Antônio Gama da Silva, who used to be professor of this faculty. but he was much more interested in the politics.
Oh.
He became Minister of Justice. He was hated by everybody because of the military government. And of course, there were some other professors in other states, but they are all, let's say, humble people. They didn't want to show himself, but Professor Erdogan wanted to. And he succeeded. He was very joyful person, very, we say carioca. Carioca is a person born in Rio de Janeiro. Very nice guy.
Yeah, yeah. I know
Everybody
the
liked
word.
him as person, but as academic, well, he was not very well spoken in the Hague Conference. For example, Professor George van Hecke from Leuven University in Bergen, he said, when I was taking part of the Hague Academy, are you from Brazil? Well, you're from Brazil. Yes, sir. Well, you look like a Japanese student. I say, yes, I'm studying at the University of Tokyo, but I'm originally Brazilian. He said, do you know Professor Haroldo Valadão? Yes, sir, of course. As a student of international law, you are obliged to know Professor Haroldo Valadão. And Professor George Fakak said, I don't like him. I was astonished. Why, Professor? Professor Haroldo Valadão is a very famous professor. No, he's not so nice person. he comes alone to the Hague Conference. He participated in all sections by himself. And once he came to his section, he said, just stay 5 minutes, and said, je suis contre. He's not a serious guy. But in 1977 or 1974, I was in the Columbia University, Parker School of Foreign Comparative Law seminar. And there was a lady professor. I don't remember her name directly, but Nina Galston. Yes, Nina Galston. She was an old lady already. And she said, she asked me, you look like Japanese, but you're from Brazil. Yes, sir. Do you know Professor Rodman? Yes, sir, of course. If you don't know Professor Rodman, you are not a student of international law in Brazil. I said, I have a great admiration for Professor Rodman. So I asked, why? He said, well, firstly, he is a very, very joyful guy. Look, he was born in 1901. Then he was, of course, more than 70 years old. But Professor Nina Galston, she said, first time I met Professor, I was 20 years old. It was on the year 1937. And there was a caravan of US students to Brazil. And you remember that the capital city of Brazil at that time was Rio de Janeiro. And today, there is a Federal University of Rio de Janeiro, which before 1960, when Brazil capital moved to Brasilia, then it was not Federal University, it was University of Brazil, which is a most representative university in Brazil. Not the University of São Paulo, but the University of Brazil in the capital. And she met Professor Haroldo Valadão, then a young professor of 35 or 36 years old. He was still, I think, assistant professor. And the Professor Nina Galston said, I was so impressed with Professor Haroldo, not only by his personality, his joyful character and so on. But she humbly asked him, well, Professor, I don't know if you know the matter, because this is not a private international law matter. This is a domestic law. Maybe you cannot know, but no matter. But Professor Haroldo said, stop. Don't say anything more. because by law, I understand everything. You can ask me anything. And the Professor Nina Galston, then more than 6 years old, she remembers something happened 40 years ago. And she was so impressed by the personality and the self-confidence. So, just 180 degrees different viewpoint of George Van Hecke and Professor Nina Galston.
Oh.
But today, everybody still likes Arnaldo Varadão, but everybody are very critical to him because he abandoned Brazil from the Hague Conference from very important. And only, did you say when Brazil came back? I think it was 1980s or 1990s, I think.
According to the website of HCCH, 2001.
2000. Yes. I came back from Japan. I became professor here in 1986, and everybody was criticizing Professor Varadão. Only after his death, because when he was alive, nobody had courage to criticize him. And then there was a movement of professor of private international in all Brazil. And finally, we, these professors of private international, considered Brazilian government to join again the private conference of private international. So this is why Brazil had joined 72, left in 78, and came back in 2001.
Oh.
I'm sorry, I used to speak so much, but our student has to know about
History, professors and history, yes.
Yes, he is considered a great jurist. But they had another discussions with another professor, very famous professor, Pontes de Miranda. But, well, this is another discussion, so I will leave for another time. So I want to ask you, Professor Kobayashi, to give your lecture, sir. And please, you make your self-presentation of your curriculum, please.
Now, Professor Kobayashi will prepare the presentation, and there's short time. I would like to respond to Ninomiya Sensei, Professor Ninomiya's comments. Yes, yeah. Actually, today I truly feel like I were a student of Professor Ninomiya. Professor Ninomiya, thank you very much. Yeah, it is really an interesting story. However, in a sense, truly very happy because Brazil rejoined HCCH. Okay. Then I will.
Private International here today is Professor Gustavo Monaco, very young professor. He's married a Japanese Nisei lady. But he's not here because he became Secretary General of the university. He is not here every day. He joins for some classes, etc. But unfortunately, he's in the campus and he's very, very busy because of the administrative affairs of the university. And probably in the future, he will be the president of the university. Oh. So, Professor Kobayashi,
okay. So good evening, everyone. It's a very honor to be here in this very historic building, and I also would like to thank Professor Ninomiya for giving me this great opportunity. And just before coming here, Professor Ninomiya kindly showed me around this building. And I know that this has a very long history, and it's a, this building is again very historic, and it's very honor for me to have give a talk to all of you in this very historic building. Thank you very much again. And I would like to talk about the institutional silence. It is my word. My word, it is a very new one. And I was wondering what sort of topics is better for all of you to talk today. And before I coming here, I was in yesterday. I was in Brasilia, and the day before yesterday, and I got to have a talk, give a talk about the contract law, international contract law at the Supreme Court of Brazil. And I was thinking about that this contract law would be better, or what? But I don't know what sort of background do you have, and you are what sort of topics are you studying? But I chosen the institutional science. This is my word, but this is a kind of study about AI and the technology, and it's a very new topics. And to give me explain why I have chosen this one, then I was in the business section. I was in the in-house counsel of Mitsubishi Corporation. This is it's a investment and trading company in Japan, and I was in there for 20 years, and so yeah, my main topics is a bit business, and I was watching the how the business is developed in the international ones, and then my main topics of study is contract law on the international contract, and also I'm very interested in the AI. How the business is utilizing the AI and legal tech. Yeah, so recently my specialized area is gradually shifted to the AI and legal tech kind of matter. So, and I would like to introduce my recent research about the institutional silence, in which I submitted the article to the international journal, and then that was accepted, and now it is published on the international international journal, so-called law technology and law international technology kind of, that is the name of the published the magazine. Then so I would like to introduce the concept of institutional silence. So let's start to the next pages. So I would like to say the question behind this study. I mean, please take a look at the right side panel. So now we have a new technology. So legal tech and generative AI, and maybe in business scene or it's a daily life. People are touching the generative AI and legal tech, whatever. So I think when the new technology is emerged, so institutions should change. That is, it always, if the technology is advanced, then we should have a new institutions in order to cope with the advance of the new technology. So in terms of legal services, so we have some questions. So, I think, for example, in Japan, we have a lawyer's law, where the only licensed lawyer is allowed to have a legal services. So non-lawyer is prohibited to give a legal services. So that is a general concept behind the licensed lawyer or licensed attorney. So question arises, who may provide them? I mean, generative AI and the legal tech is providing a kind of legal services to everybody, for the individuals and small companies and large company, whatever. So is it okay for legal tech company to provide legal services to their companies or SMEs or consumers? That's a very simple question. And institutions have to respond to that question, right? And so in connection with that, we have a question about who counts as legal advice. I mean, who can provide legal advice? That is a very simple, very serious question. So institutions need to respond to that question. Okay, so this is the basic question. But sometimes institutions, I mean, government agency or courts or whatever, is not able to respond to that question. So sometimes they are silent about the question. So that is sometimes that is the case. So my question is, how has the Japanese legal system responded to this challenge? This challenge means a new technology is emerging, and they are, providing a sort of legal services to the consumer. So that is a question which I would like to raise. Okay, and so another important point is access to justice. Legal tech matters for access to justice. Um, legal tech in Japan, I think the legal tech is widely spread among the business scene. So because in the business there is a legal department. The legal department is specialized in legal work, and they know legal matters very much. So they can use the legal tech or generative AI for the legal purpose. That's okay because and the user who is using the legal tech is lawyer, so no problem at all. But the point is that so what about the normal consumers, individuals? Is it possible to use the generative AI for their own legal perspective and their own legal matters? So then the problem occurs. Because the consumer itself is a kind of layperson for the legal matters. So layperson can, if the layperson asking a kind of legal question to the general AI or legal tech, then getting answered, is it okay for they understand the such kind of legal response from the general AI correctly, or can they really handle the legal kind of things through the legal tech or general AI? That's a serious question. But at the same time, we have an access to justice problem because consumer is sometimes not able to get proper legal advice from the lawyers because the lawyers are very expensive. A big firm is just providing services to a larger corporation. So smaller companies and individuals, consumers, really need legal services. And legal tech is sometimes very good tools for consumers because it's very cheap and it's just $10 or $20 in a month. They can get advice through the generative AI. So it could be better for the access to justice if the generative AI and the legal tech can provide a sort of legal services to the individuals. So that is another matter. So please take a look at the right side, right panel, and small businesses and the individuals has two choices to access the legal services. The left line says traditional legal services in which the large law firms, lawyers is providing. So, but there is a higher cost and sometimes limited access because small individuals is not able to afford those services because of the higher cost. So another option is the right side. Right side option is the digital legal support. So if they are getting support through the generative AI, so it could be achievable by potentially lower cost and it's a wide access. So in these two channel, individuals is presumably get the access to justice. So that is a potential legal texts and the generative AI's merit for the individuals. Okay, so this is assumption. So then the problem is formal monopoly of lawyers. It's Article 72 in Japan. Article 72 of the Attorneys Act says only lawyers is able to provide legal services. No other specialist is not. So that is the rules. No lawyer may not provide legal services for compensations. So I think as long as we maintain this philosophy, so this potentially concludes that the legal tech and the generative AI is not able to have legal support, right? But in reality is that the generative AI is very, now the capacity for them to have legal services, legal advice is going, it's a very it's advanced at this moment. So that is the one of the problem. So institutions have to respond to this concept. Why lawyers has monopoly? So and historically speaking, in any country, there was some problem. Lawyers are also able to provide services, but only to the larger corporation. I'm not sure whether in the Brazil, lawyers, how many law firms are providing legal support and what sort of, law firms is providing support to the legal advices to the consumers or individuals. I'm not sure, but generally speaking, big firms, law firms is providing, only looking at the larger corporations, and then so somebody have to fill the gap in which the individuals is not able to get the legal support. So in Japan, historically speaking, adjacent profession was filling the gap. I mean, there was a everyday legal needs. Please look at the right side panel. Individuals and small businesses has really legal needs. And there was an adjacent licensed professions. One of the judicial scriveners, administrative scriveners, tax accountants, patent attorneys, labor and social security consultants. Those are not licensed attorneys, but licensed on the specific topics. So what we call adjacent professions. So in Japan, adjacent professions was filling the gap between the needs for the legal support and demand of the legal support. So the judicial scriveners and administrative scriveners mainly performing legal-related tasks, and other specialists assist with tax, labor, patent, and social insurance matters. Then so that's why individuals, small business doesn't have any problem in getting legal support, historically speaking. That is our Japanese history of why access to justice problem has not occurred until recently. I'm not sure whether the Brazilian the legal market there will be some sort of same problem or not. I would like to ask a question later on, but yeah. So in Japan, there was this kind of contractionary equilibrium. I mean, so if we look at the right panel, legal needs are absorbed by adjacent professions, judicial scriveners, administrative scriveners, tax accountant. They are absorbing legal needs. Then going to the left side, justice gap stay hidden because those are filling gap. So the shortage of the number of the lawyers, licensed lawyers, is not having a serious problem. So that's why lawyers, Article 72 of the Lawyers Attorneys Act the concept of the lawyer's monopoly, licensed lawyer's monopoly, not raise a concern. So the existing order is preserved. Okay, so pressure for reform remains weak. So there is no pressure for the reform for the Article 72 of the Attorneys Act. So then, adjacent professions continue to absorb the legal needs. So in this cycle, so there was a contractual equilibrium, right? So lawyers are having a status as a monopoly, but on the other hand, actually adjacent professionals is filling the gap. So this is a kind of balance of the professional hierarchy. So I think, United States has a little bit different situation. So in the United States, legal tech has produced visible disputes over the unauthorized practice of law. I mean, please look at the right side, and there was a lot of famous court cases involving LegalZoom, which was, a very famous legal tech company, which is providing a service to the consumers, right? So this 2011 Jensen versus LegalZoom, and 2022 there was another case is Absolve versus James. And those are raising a concern about whether the legal tech company is okay to provide the kind of legal services through the internet or through the generative AI to the consumers. That was disputed in the actual court cases. Then bar associations and the other actors challenged this LegalZoom and Absolve with those legal tech companies. So that through the court cases, so that some problem was visible. Yeah, that is the United States cases. And Germany also, courts opened the door. There was two very famous court cases, Lex Fox and Smart Law cases, both of which were, both of those companies are providing services to the consumers. So Lex Fox is automated, it's providing services to the tenant who is claiming the rent control kind of model. Smart Law itself is an interactive contract and document generator, and Bar Association has claiming that this is violating the Lawyers Act. Then, through these kind of the court cases, German has already, raised the concern about what sort of services legal tech can do and cannot do. So this is the courts open the door for how the Lawyers Act should be on how the lawyers monopoly could be. So that is that's the U.S. and Germany has a lot of cases through the active litigations, right? But Japan's a different path. As I said, adjacent professions has absorbed the legal needs. So, no, there was not such a concern was raised among the society. And also, there has been no widely reported legal tech lawsuits concerning unauthorized legal practice. So public discussions focus mainly on tools used by larger companies. So in Japan, legal tech services is only provided only to the larger companies and not individuals, not small corporations, small companies. So I think partly because the adjacent profession has absorbing such kind of needs for the smaller companies or the individuals, but In any case, Japan doesn't have not such litigations. Yeah, so the problem was not visible so far. So, but Ministry of Justice has had the guidelines in 2023. It clarifies some issues concerning AI contract review, but larger question unanswered. I mean, the target of the Ministry of Justice the guideline is only limited to the for larger corporations' use of contract review tools. It's not targeted to the consumer nor individuals. So Japan's target is, there was a notion that the legal tech is just for the larger corporation, not the smaller and consumers or individuals. So that was a situation in Japan. So then I would like to raise to have a new concept, institutional silence. I mean, in Japan, that is a situation where the institutional silence is now has occurred. I mean, institutional silence does not mean that institutions do nothing. It means that they avoid confronting the central issue. Central issue in this problem, central issue is whether legal tech is able to legal services to the consumers. That is central issues. So, in Japanese institutions, Japan does not respond to that question. So regulators may respond only to a narrow part of a larger problem. So larger problem is for the consumer, for individuals, whether they can get the legal service from the internet or for the AI. That is a larger problem. But Ministry of Justice only answer that question for the larger corporations, legal, contractual review kind of matters. They are, targeting very narrow of a larger problem. So, and they may use very vague guidance instead of making clear policy notice. But in the United States and Germany, there was, there was a lot of court cases in which the central problem was argued and sometimes settled through the court cases. So that was a little bit different between the US and US, Germany, and Japan. Okay, so please take a look at the right side. There was a visible response by Japanese regulators. So there was, of course, there was guidelines, a limited clarification, and a formal statement. There is, but there was also unaddressed issues. Structural reform, no structural reform, no access to justice concern. Or there was no new professional boundaries, and there was no argument about the consumer-facing legal tech problem. So there is a lot. There are a lot of unaddressed issues. That is the situation. So I would like to define the institutional silence. There was 3 types of institutional silence. One is a structural silence. Structural silence means the institutions, regulators, does not recognize the problem. So that's why they do not understand the problem. So there was no action. So that's a structural silence. And second, selective silence. Regulators, institutions recognize the problem, but deliberately avoid it. That is the selective silence. And due to some reason, because raising a concern that's happen problematic and that's a serious problem in the society. That's why institutions deliberately avoid doing any action. And symbolic silence, it is a very confused. Institution regulator recognize a problem, but then appears to react, but does not address the central issues. This is a sort of Japanese problem, symbolic silence. So what we call this Japanese situation a facade sustained silence. Japan combines selective symbolic silence to preserve the appearance of a coherent lawyer-centered system. So Japanese regulator would like to preserve the lawyer-centered monopoly system. Yeah, but reality is generative AI and legal tech is invading in the legal field. But regulators do not want to see that. So Japanese institutional silence means if take a look at the right side, so lawyer the former order is a lawyer have exclusive authority, right? But the actual practice, legal assistance is provided by multiple providers, including legal tech. And the system appears coherent. It means that that notion that lawyers has exclusive authority is preserved. Yeah, on the former order, but the service provision is fragmented actually. And third one, the professional boundaries remains clear. It says in the formal statement, only lawyers is authorized to do the legal service. But the actual situation, boundaries are blurred in practice. A lot of generative AI and legal tech is doing actual services. So an actual practice in the formal order is split. Right? This is a serious problem. And this is what we call facade sustained silence. So why limited adoption in Japan? So I did survey targeting the small corporation or larger corporation, and it's very small survey of the larger company. 55 company was responding to my survey. And SME, small and medium company, 45 company has responded to my survey. And this really combined 100 firms was targeted at the survey. And we had a propensity score matching. It is a very technical things, but finally 76 farm was matched for those surveys. So based on the 76 farms, and we have conducted research whether they are utilizing legal tech or general AI for contract drafting and contract review, legal research, knowledge management. So these are four categories of the matters, and whether these 76 firms are using the general AI or legal tech. So then the result that the first survey found is it's very interesting. Contract drafting, please take a look at the right side. 12.5% of the company using generative AI only, but legal tech, or the company who uses legal tech only is only 3.1%. For contract review, 6.7% is is using the only generative AI, and 0% for legal tech only. So if you look at this one, we can find the very important things. Companies are using generative AI, but not using legal tech. I mean, generative AI is more spread at the business companies and small, including small businesses. That's a very interesting conclusion for the survey. So that means generative AI it's very easy for individuals, consumer to generate AI, right? And it's that is because generative AI doesn't label legal services. It is not they are not providing the OpenAI and Claude, and those are not providing the services just for legal. It's not just a general service. So that's why people are easily getting utilize the generative AI because they are not specific for legal. But the legal tech itself labeled legal. So as long as it's labeled legal, so then the serious concerns occur. Oh, is this okay? This is legal services. Is it violating lawyer's law or attorney's act? And that sort of question arises. So one of the implications for that survey is that general AI disrupts the existing equilibrium because it operates outside the hierarchy of licensed professional, right? So generative AI is not generally providing the kind of AI service and not for the specific legal service. So that's why people can easily access the generative AI. So that could be one of the implication found after the survey. Okay, so institutions do not respond to the spread of generative AI. That is another problem. So the regulator cannot react to the generative AI because generative AI is already spread all over the world. Everyone is using that. So once the institution says, regulator says, okay, it's not okay because of the Lawyers Act and only licensed lawyers are allowed to provide the services, then there was a serious problem. Actual reality is, and everybody is using the legal services through the getting support from the generative AI. But the framework, the institution says only lawyers is allowed to provide legal services. That's a very problematic. So silence may preserve stability in the short term. I mean, silence means as long as the regulator is silence about generative AI, that's okay. Nobody's raised a concern. So silence may preserve stability, but it can gradually weaken the legal system's ability to govern change. I mean, regulators and users can temporarily avoid conflict by not describing AI use as a legal advice. But as AI becomes more capable, I think at this moment, AI is very capable of doing the legal services. So gap between formal rules and actual practice will grow. That's a problem. So continued silence, institutional silence itself may lead to institutional drift and erosion of regulatory boundaries. So that could become a serious problem in the step by step in the near future. That could be a problem. So institutions have to respond in the end. So conclusion, silence is also the regulatory choice. I mean, at this moment, the silence is okay as long as the regulator do not say anything about generative AI in terms of the Attorneys Act or lawyers' law. So Japan has preserved lawyers' authority by containing alternative providers within the professional hierarchy. I mean, Lawyers Act has produced adjacent professionals. And they are absorbing a gap. So there was no problem on the face of it. But generative AI now challenges this distinction between regulated legal service and the unregulated assistance. So we have a task, which is to reconnect legal norms with actual practice. So legal institutions can no longer remain silent. The issue is how they can respond responsibly. So that is my conclusion. Silence is also regulatory choice, but it could long. And thank you very much for kind attendance, and my presentation is over. That's it.
Well, alguém tem alguma pergunta aí, professor? Seja à vontade. Por favor, algum? Listo.
Yeah, I would like to question. I have a question. What was the situation in Brazil? Is there any argument about the lawyers' monopoly or lawyers' territory?
Professor
Mm.
Bayashi-san, thank you for your lecture. In Brazil, we are facing three different situations
Yep.
between the judges, lawyers,
Mm.
and the public attorneys.
Mm.
They are using too much the generative AI, and the hallucination of the AI are creating sentences, rulings,
Mm.
petitions, and criminal presentations with fake jurisprudence
Yeah.
and with articles that is not placed in the law. And we are facing the problems of how we can punish and get better as jurists to avoid this. In Japan is happening something similar with people, the lawyers, mostly the judiciary system, are using without any kind of control the generative AI and have some situations just like in Brazil. I don't know if
I see. You are asking about lawyers utilizing the generative AI, and then generative AI is providing hallucination, and then in the present courts. Yeah, there's sort of things, but I don't think that if I'm wrong, so please tell me. But I don't think that there was some punishment about the hallucination, submitting hallucination information. But in the United States, there was very serious about the hallucination provider. I mean, if lawyers is submitting a report which contains AI hallucination, then that lawyers is punished uh, by the bar association. I'm not sure, but it's not such kind of things in Japan. That is my understanding. Yeah, so it's not. So no serious regulation is made by Japanese Bar Association company. The Japanese Bar Association is very focused on you know, protecting the smaller law firms, which is, I mean, they are, they are thinking that the generative AI, advent of generative AI is shrinking the size of the lawyer's business field, then that could be problematic. So they want to protect the lawyer's business field. That is the more main concern. Kind of hallucination point is not becoming a serious problem at this moment.
And thank you.
Mm.
And the other problem I have in Brazil was, I don't know if are used from the prompt injection.
Injunction?
Yes, because all the judiciary procedures in Brazil are digital.
Yeah, I
So
know. I hear that.
we had a case in the Pará state where two lawyers, they put in the petition prompts that cannot be seen by human eye, but can be read by the intelligence to make some prejudice for the other part. But the court system identified it, and they make a huge fine, more or less, say $8,000 for each lawyer because of this bad use of the generative models.
I see. Yeah.
So we are facing some kind of issues here in Brazil right now.
Yeah, I understand. Yeah. The day before yesterday, when we had a presentation and we had a session in the Supreme Court, and we understand that the Supreme Court is very aggressive about using AI, and they have they established a good system itself, and and that's why they at the same time they're very serious about the wrong utilization of AI. I understand. So in my understanding, Brazil is a much more, advanced compared to Japan's situation. Maybe. Thank you very much for your
Okay,
comments.
thank you very much, everybody. So nice. Now we have Professor Martinez, Professor of Osaka University.
Which one? Perfect.
So thank you so much, everybody. I'm Mary Shimis. I come from the University of Osaka. And I assume you are already tired after absorbing too good information. So I would like to make it very brief. And first, I would like to introduce myself. Actually, I was, until 2 years ago, the government official. Actually, originally, I started as a private lawyer. But 10 years ago, I think it's already 12 years ago, but I wanted to do the WTO dispute settlement procedure. So I joined the Ministry of Economy, Trade and Industry to deal with the WTO dispute settlement procedures. But the office is kind of a legal department to assist any kind of international trade law. So I became interested in the field after that. And 2 years ago, I became an academic. So with that background, naturally, I became very interested in critical minerals issue. And today, I would like to speak about the impact of G7 and Australia's framework on critical minerals, on foreign investment in South America's industry, and international trade, though. So I promised you to make it brief, so let's go. So what I mentioned by G7 and Australia initiatives here is that maybe you all are aware that China has been introducing the export control of rare earths recently. And Japan and US and EU are all very alerted by that move. Actually, some business are really struggling for it. And so with that emergent situation, G7 publicized some action plan and initiatives. And here I would, today, I would like to focus on the move to introduce standards-based markets and the latter half of the yellow parts. I'm sorry, I need to explain about the standards-based market first. Standards-based markets sounds a little bit neutral, but when you see the description here, which is phrased by paragraph, critical minerals markets should reflect the real costs of responsible extraction, processing, and trade of critical minerals. So here, standards-based markets is some mechanism to exclude low-price products from dominant suppliers. And the second part of the yellow part, here, there is another, suggestion from the G7 to discuss is that the tools, for example, investment policies, trade measures, price floors, or other mechanisms to reduce and eventually eliminate our dependence on critical mineral supply chains dominated by non-market policies and practices. Maybe you are familiar with non-market terms. It's usually imply China. And here again, this is all about both of the terms used here are all about excluding low price products from dominant suppliers. Often it would be China. And what would be the impact of these initiatives to Brazil or other South American countries? Because they are open to investment from both groups, right? China and United States or other G7 countries. Can Brazil ignore all those initiatives, or will there be any adverse impact on South Americans' industry? And if there is an adverse impact, how to address such impact? That is first of my focus. And the second is, maybe some of you have studied international trade law, but under the international trade law, one of the core principle is most favored nation principle, which is not to discriminate among different countries' products. But here, it is basically to exclude certain countries' products, right? So it is obviously against MFN principle, and the issue is whether such violation of MFN principles will be justified or not. So there is an issue under the international trade law as well. So that is the second point of my focus. And with this maybe it is already apparent, but first we need to know the background of the problem. Why the China or other countries like Congo for, I think, certain minerals. Congo is also a dominant producer, but there are some limited dominant producers for critical minerals. But why is it? That is because of the unique high risk of investment for critical minerals. Here I listed some elements. So first, considerable time and resources taken before the commencement of business. Mining business is a huge resource requiring business. So there's obviously a huge financial risk to conduct the business. But the second part is also very, very important. Critical minerals are different from base metal in the sense of the market size. These are the very, very small market. So it could be very volatile in terms of price. And actually, there were some actual examples of predatory pricing or price manipulation, meaning that when the new source come up in the market, the dominant producers can suddenly increase the supplies and make the market price very low. And then the new source cannot compete with the low price products, even though they really need to operate with a reasonable profit. They cannot. Then the new industries would be bankrupt, right? So the second one that I mentioned here is very, very important part of the problem. And maybe the third one is also very important. So the cost for the mining or refining business would be really huge because of the electricity or compliance costs with regard to environment and labor regulations. And maybe I would like to stop here because of the time's sake. But here, so about the price issue, this is linked to the standards-based markets, meaning if you really comply with the environment or labor regulations, the cost should be higher. So the low price products mean that they do not comply with standards. That is the basic logic here, right? So it is linked to the background that I mentioned. And then, so I would like to skip here. Actually, here I would like to compare some policy initiatives actually implemented by here, Japan, Australia, and Brazil. But basically, many of the domestic policies implemented in various countries are comprised of these tools. First, you need to focus on strategic materials for your own country. So you would need to do the priority analysis, right? So every country is doing this. But then, as I mentioned, it is a very resource requiring industry. So you really need to finance. And I think in a traditional sense, the business was too risky for banks to make loans. But here, the public finance will be coming in. You really need public assistance, government interruption in a sense, government assistance, industrial policy will be needed to help the new business to operate. So there's a huge amount of public financing coming in the market. And then the third one, stockpiling. This is actually implemented. This was actually implemented in 2010 by Japan when they first experienced export prohibition. Not export prohibition, export control of rare earths by China. And actually it worked in an emergent situation. So currently many countries are starting to introduce the stockpiling. And the fourth one, aggregating demands and supplies, is also very important. It is just to help the market system by, allowing the demanders and suppliers to register their, possible demands and supplies and ensure the matching of the supplies and demands. And I would just skip the recycling, but the last part is the one that I need to focus today. So the price mechanism system implemented at the border to exclude low price products. I would call it as an external shields from now on, but external shields actually have not been implemented so far. This is the topic that for which the discussion has been just started, but I think the likelihood is very high because the price is so different from the dominant Chinese products and the other possible diversified sources products. And I'm sorry, here just a brief description of this comparison is that maybe I would like to focus on just the yellow highlighted parts. So actually, Australia is, I did not write in this paper here, the slide, but I mentioned about safeguarding against foreign interference. So Australia puts some general guidelines regarding how to treat the foreign investment into critical minerals specifically. And in actual practice, they have rejected some investment from China to their critical minerals industries. Recently, I think in May, Australia ordered 6 Chinese-related investors to divest from specific rare earth industries. So they are making use of the investment review as an protect their own market. And in contrast, Brazil. I think there was a news article recently, last week, President Xi of China and President Lula of Brazil did the telephone conversation, and President Lula's position was clear to welcome China's investment in critical minerals. And also there was another news articles, a little bit of in advance, stating about the Brazil's denied United States call to restrict investment in the mining sector from non-market actors. So there is a kind of obvious contrast about how open they are about the foreign investment. And I think the background here, I'm sorry that the picture is a little bit disrupted. Here, the background of that difference is, I think, basically described by the 2 elements here. First one is the industry structure, and the second one is their position in the United States and China conflict. First, about the industry structure, Japan is uniquely among those 3 countries, a country that do not have any substantial domestic reserves right now. But they have substantial manufacturing end users like autos and semiconductors. And so they really need critical minerals for their core downstream producers. So they're really serious about investing in foreign mineral-rich countries other than China. So Japan is so willing to invest in Australia and Brazil. And on the other hand, Australia and Brazil, I think they are common in this sense that they are both rich, let's say, natural resource countries, but they have been struggling to develop their refinement and processing capacity so far. And with regard to the downstream producers, downstream end users, it's just a comparison problem, but compared to Japan, they have lesser concerns about procurement for their end users regarding the critical minerals. So with regard to industry structure, the core elements are a little bit different, but all of the 3 countries really need production expansion regarding the critical minerals. And on the other hand, with regard to the position in the United States and versus China conflict, here the comparison would be Japan and Australia versus Brazil, because I think Japan actually is, I think it's obvious, right, for everybody. They have experienced the suspension of critical minerals exports already multiple times. And so Japan is so alerted on the China's dominance. and they are really close to China. And so they are subject to arms threat by China as well. And on the other hand, with regard to the United States relationship, they have a very, 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 very strong relationship after the World War II. You know, Japan does not have military, and both in terms of economic and arms relationships, they have a very strong tie. And Australia, actually, I visited Australia for critical minerals research purpose last year, and I was surprised that the atmosphere against China is less, alerted than Japan. They have a good trade relationship, so they want to maintain a good trade relationship with China. But regarding accepting investment into critical minerals, which is the very, very strategic industry, only on that point, they are really, really cautious. So, and I think the background is that they have already experienced predatory pricing by China's industry in the past. So, and with regard to the United States relationship, again, Australia actually has a long-standing armed cooperation relationship with the United States. And actually, I think recently, they started to, describe the arms relationship against China, saying that the missile scope of China is beginning to reach to Australia. So I think the degree is a little bit different from Japan, but still they have some alert on the arms issue as well. But I think with regard to Brazil, it is totally different, right? I think with regard to Brazil, actually, I would say that there might be some price predatory issues in future, but here I think the stage is still at a very early one. So I think compared to Australia, Brazil is not that alerted by the China's dominant practice at this moment. And geologically, Brazil is situated furthest from China compared to other countries. And with regard to the United States relationship, again, obviously, I think Brazil is subject to the strongest, coercion by the United States at this moment. So the relationship is a little bit distant from the United States compared to other two countries. So with this, I could say that, I'm sorry, maybe I should go here. So the thing is, because of the elements that I have just described, I think the basic attitude or approach of those countries would not be changed for the midterm or long-term future at this moment. And what will be the impact of then the G7 and Australia policies regarding external shields, etc.? First, with regard to standards, I think maybe there is a very famous term that I think regulatory imperialism that I've just learned from the other panelists in Brasilia. But if you provide standards in a very powerful market, then the other producers who want to export to that market need to comply with the standards, right? This is, I think we would call it Brussels effect recently, because that EU is doing the introduction of many standards. And in that sense, even though Brasilia does not want to impose standards, if they want to export the outcome products to other markets, the downstream producers would need to comply with the standards. And I think especially the large multinational corporations, which will be a good purchaser of the critical mineral products, would need to comply with the standards to be implemented by the G7 and Australia. So there would be an impact in that sense, I believe. And the standards is a very powerful tool, in a sense that it will be linked to other measures like subsidies or stockpiling or external shields. So this is a very, very important, I think, aspect that might be need a good attention. And with regard to external shields, I think that maybe there is not much adverse effects added to standards, because currently all the countries, United States, European Union, Korea, Japan, and China, all countries are so interested in investing in Brasilia. And so the countries who did the foreign investment in Brasilia would not exclude the outcome products coming into their own market, right? So in that sense, the external shields to be provided by the G7 countries might not affect to the outcome products of their foreign investment. But still, there will be the two different separate, supply chains within Brazil, might be in future. Like Chinese invested products will be coming into China markets, but would not coming into the G7 markets, and maybe vice versa. And that will be a little bit of less efficient outcome compared to the real free trade market. But still, I think it is not avoidable. And so there might be what we can call decent decoupling in that sense. So there will be that kind of effect. But still, Brazil, by becoming open to both investment, they can get the larger amount of investment and larger downstream markets. So I think in that sense, external shields might not affect, at least in the short term, for the Brazilians accepting foreign investment. But with this, what can be done in practice? I will skip this. So with regard to standards, I think it will be influential, as I mentioned. So it might be constructive to, give some influence on standard construction, because standards can be arbitrary by like specifying certain price level as as a price that complies with the environmental or the labor standards level. But those prices or costs would be very, very different from each country. So I think it is really, really difficult to put those quantitative criteria to reflect the required standards. But so the desirable standards will be more flexible and to be more backed up by the valid regulatory considerations. So in that sense, in the long term, that kind of workable standards that will be persuasive to any country would be desirable. So in that sense, standard construction might be something that Brazil and other countries might need to work on. And with regard to external shields, I think in the end, those external shields will be described by the concern for the supply chain resilience, meaning that concerns for the risk of relying in a single, maybe adversely source. And that concern might be valid in some sense, but still, even if you accept some adversely foreign investment in your country, if you provide a certain protective mechanism to reduce the influence from that foreign countries, then maybe the business themselves are neutral, will remain neutral. So that kind of the protective process regarding the investment review might be more crystallized domestically and internationally further. So far, I think that kind of investment review is classified as security issues. And if you classify anything under the security, it will be under the very secretive procedures. And that would make the process a little bit less transparency and less predictable. But I think currently everything about something securitized. So that kind of elaboration, crystallization about how to handle those new security, economic security, can be developed further in the long term. And I would skip the other parts about what about international trade law. So as I mentioned, there might be the tension between the MFN principles, but the issue here is WTO law, the most powerful, so far, the most powerful international economic law, provides only specified justifications. And those justifications provide environmental considerations or labor considerations to some extent, but there is no specific elaboration on supply chain resilience because it's a very new issue. And so how to incorporate that kind of notion in the international economic law is a very, very important, crucial issues to address right now. And the details I would skip here because I think its time is already exceeded and I think you're already tired. So thank you so much for your attention. That concludes my presentation. Thank you so much.
Well, thank you, Professor, for coming today and lecturing to us. So I wanted to ask you what you think, how do you define the relation between Japan, commercial relation between Japan and China right now? And what do you think it should walk to, like how it is today and what you think it should be like?
Thank you so much.
Really?
It's a very good question to ask for diplomats at this current moment. But what is it? The obvious truth is that actually United States and China are the top two trade partners for Japan. It's kind of exceeding other countries to the far extent. So like Australia, Japan has a good trade relationship still at this moment. So commercially, I think many Japanese countries want to continue the good trade relationship with China. But I think you might be aware, it is currently a huge topic in Japan, but after Takaichi-san became prime minister, there is a very, very adversary relationship between China and Japanese companies are really wary of those export controls expanding gradually from now on as well. So they need to be cautious and they need to diversify the sources as well. So it's a really, really difficult balance, but that both will be needed, meaning that to maintain the existing trade relationship with China and to diversify the sources with China. And hopefully, I expect the diplomatic relationship will be improved, but I cannot say I have a very good, valid reasons to say that I can expect a good outcome in a very near future. So it's just to, trying to balance both elements, meaning the maintenance and the enhancement sources.
Thank you very much.
You're welcome.
Uma outra pergunta? Okay, thank you very much.
Thank you.
Shimizu. And well, since we have a time schedule and so, I would like to thank you very much for our three professors who came from Japan. They are tired because of time lag and so. So I want to thank you again in the name of Faculty of Law, University of São Paulo, to thank you very much for three professors and invite them probably they will be here next year. So that maybe we can have more time next year to this kind of interchange, academic interchange. Thank you very much indeed. And now I'd like to invite everybody to come here to take a picture with professors. Huh?